SJC-12620, Commonwealth v. Mark Adams.
Mr. Kavaja, good morning.
Good morning, Your Honors. May it please the Court. My name is Ilir Kavaya, and I represent the appellant Mark Adams in this matter. Your Honors, police officers do not have the authority, pursuant to General Law, Chapter 140, Sections 131 and 129D, to confiscate a licensee's firearms immediately after serving him with an administrative suspension notice pursuant to the statute, absent either exigent circumstances, a warrant, or other court order. To hold otherwise would be to depart from longstanding precedent about statutory construction, and it would also violate Article 14 of the Massachusetts Declaration of Rights and the Fourth Amendment to the United States.
Let me ask you, so let us imagine somebody has a license to carry, and that license is revoked. Can that person be charged with carrying a firearm without a license?
If the person's carrying them or has immediate or direct control over them after the suspension, it's possible that the person may be carried. For instance, if the police officers were to have stopped Mr. Adams on the street and he had a firearm on him, that's a different scenario. But in this particular case, Your Honor, the firearms of Mr. Adams were locked inside his house, in his abode, in a safe. So there were two barriers, constitutional barriers, to the police accessing those firearms. Number one is the home, and number two is the locked safe with a combination. So in that hypothetical that Your Honor poses, maybe, depending on the circumstances, in this particular case, the officers did not have any authority, statutory or constitutional, to go seize the firearms.
So did he have an FID card?
He had an LTC, Your Honor.
Sorry?
He had a license to carry. So
Okay, but with that license to carry, when that is revoked or suspended, then he has no legal ability to possess a firearm.
So arguably, yes. However, because of the administrative suspension, so there's three different statutes that the legislature has passed, which would suspend somebody's either FID or LTC. Two of them give the police authority. Matter of fact, they obligate the police to immediately go and seize the firearms. One of them is the immediate risk, substantial risk, extreme risk protection orders under Chapter 140, Sections 131R and 131S. There's a judicial process. The police can initiate the process. The standard of proof is preponderance of the evidence. And the statute states that the police shall immediately confiscate the firearms. The person holding them shall immediately surrender them. So that's one way the police could have gone about this, which they didn't. The other statute the legislature has passed is 209A, abuse prevention orders. Again, judicial process. There's the judge who makes the decision. There's an order that's issued. There's a standard of proof. Then the police, and the statute states, the law enforcement officer shall immediately confiscate the firearms upon service of the abuse protection order.
So he has no FID card. His only authority to possess a firearm was the license to carry. That was revoked. Why could they not arrest him for illegal possession of a firearm since he had neither an FID card nor a license to carry?
Because the third, well, so there is a difference, Your Honor, respectfully, between a person who has never had an FID or an LTC possessing firearms, and between a person who has lawfully obtained such license, has bought firearms, stores them properly, and then his right to possess those firearms has been administratively suspended. So it goes to the direct language of the statute. The previous two statutes that I just mentioned give, there's a judicial process and there's mandatory confiscation by police officers. In this third statute, which is 140, 131, and then it directs to 129D, the burden to turn over the firearms is upon the licensee. There's no right that the statute confers upon police officers to confiscate such.
Well, but they went and knocked on the door and asked them to do that.
Right. No. Well,
He didn't, so he did not fulfill that part of the bargain. so to
Well,
speak.
Your Honor, actually, he did. He allowed them to serve, he allowed them to serve them with the notice. That's all that the statute,
But he didn't turn over the firearms.
correct, but he didn't have to at that very moment,
Why not?
because the statute says
Despite,
so.
so tell me again which one, 140? Tell me
140
exactly what it says.
140, 129D says, upon being served with the suspension notice, which is the administrative suspension notice, a card holder, a license holder must, without delay, either deliver or surrender, so there's one, deliver or surrender such firearms to the licensing authority unless there's an appeal pending.
Well, that's where we get into the issue in your case, isn't it?
Well, yes, and I would
So
respectfully...
do you agree that if there was no, if he had had an opportunity to appeal and there was no appeal pending and the police knocked on the door with that notice, he would have been off, they should have given him the gun? He should have given them the guns?
Potentially, Your Honor, and the only reason I'm a little skeptical about that characterization is because the statute itself says that the licensee shall, shall without delay either deliver or surrender, So hypothetically speaking, or factually speaking rather, concretely speaking, a licensee has the option to be served with a suspension notice, administrative suspension notice, say, thank you very much, officer, I will ensure delivery of the firearms to the station within 24 hours. So
But there's been a determination that the license is not suitable. And I understand that 129D seems to be at war with each other, and you can't reconcile surrender immediately and unless there's an appeal. But here we have the police coming, they're coming for the firearms, the defendant's found not suitable. How is it that he can maintain control of the firearms during the appellate process? Don't you have to rely on post-procedural due process?
Well, Your Honor, there are two sort of prongs to that question, and thank you for asking it. The first one is, in this particular case, the firearms are locked in a safe inside a house. So for, and as this court knows, to have possession of something, you need to have at least some sort of control over it. Mr. Adams could have very well gone to his brother's house, who had an LTC, and said, hey, brother, can you go take my firearms and take them to the police? So it's not necessary that upon being served with a suspension notice that the person has immediate possession of them if he is not within the vicinity of the firearms.
But I think what Justice Lowy has asked you, if you could answer this question directly, is the person's been found not suitable, that the statute does say unless an appeal is pending, and you're arguing for the safe haven, but I think the concern that we're all voicing, which you should address, is, well, if there's an incident of domestic violence or there's somebody that the licensing authority deems not suitable to have a gun, why should we jeopardize the risk of a domestic violence incident because the police have to walk away? I mean, how is that safe haven and a suitability? How do they live in the same world when we're concerned about gun violence and domestic violence?
Your Honor, if the police officers were concerned about gun violence and safety of anyone, they had 140, 131R, and 131S to go to the courthouse. It was 3 weeks after they received a complaint from the medical doctor. They had 3 whole weeks. They could have gone to court anytime they chose to. They chose to take the administrative suspension route, which is not an adjudication by a judicial body, and which is very distinct from... So the suspension process is very distinct from the other two that have judicial oversight on them. So it's by design that the legislature had this language to not to give the police so much unfettered discretion about confiscating someone's firearm without ever being a judicial process. No exigency either.
Well, is there no exigency? I mean, there is an exigent circumstances in sort of avoiding a search warrant. But we have a domestic violence incident and the man has 13 guns and his wife is concerned enough that she brings this up. So does that give them the authority to suspend the license? And there is no appeal pending, right? There is none.
Well, Judge,
And they could have given him if they didn't think it was so exigent, they could have given him an opportunity, right? They didn't have to send the police right over there. They made a determination to go forward, right?
Well, 3 weeks later, but
But they don't, they could have done it differently, right? They could have given him an opportunity to file an appeal, right?
well, they could have gone to court in the 3 weeks that they.
Well, but they
waited.
could have given him sort of administrative notice and not, right? And allowed him to appeal before the police showed up, right?
But they should have pursuant to the statute, to the
But they-
plain language of the statute, they should have done that. He has the right to do
Well,
that.
they meet the plain language because there's no appeal pending. The language may not make perfect sense, but they meet the plain language, don't they?
No,
There
they
is-
don't.
There is no appeal pending.
Well, there can't be an appeal pending when you're immediately served upon it. It's impossible in law and philosophically, hypothetically speaking, it can't be. So in order for that part of the statute not to become superfluous, we have to read it as someone having some time, whatever the time frame may be, to file, at least to file an appeal, maybe consult with a lawyer like Mr. Adams did. And Your Honor,
Or could the legislature have decided, well, we're going to give the administrative body some flexibility about whether they're going to give him that chance, depending on how dangerous they consider him?
well, they gave them that chance through 131R and S. So the legislature gave the police a choice. You have two different statutes. If you want administratively suspended, that these rules apply. And if you think this person is so dangerous, we have an exigency, then go to court. They had 3 weeks to go to court. Clearly,
Does that include mental health issues as well, the statute you just cited to us? If there's unsuitability because of a mental health issue, do the police have a similar right?
I believe the police have a right based on specific articulable facts, whatever they may be, whether it's violence, mental health issues, whatever concerns the police may have, to go to court and apply for an extreme risk protection order. Absolutely.
So-
Take a step back for a moment.
Yes.
And address the mootness issue. There's serious constitutional issues. We don't just blithely reach constitutional issues. And I'm not sure that the interference with the police officer crime complaint really is driven by this failure to turn over the firearms. And that charge was dismissed. So why do we get past mootness here?
On that particular issue, Your Honor, I would respectfully suggest to the court that we get past mootness because the issue brings up it's an important issue, number one. It has been fully briefed, number two, and it has the potential of repetition without escaping, without being justiciable, basically. But not only that, it is the Commonwealth that made an issue out of it, the surrendering of firearms during the trial. I stopped counting at number 35. I counted 35 different instances in the trial transcript where the Commonwealth mentions guns, failing to surrender the guns. He didn't give you the guns in their opening, in their closing.
Because that was relevant to the interference with a police officer. If he didn't have to turn over the firearms, if you're absolutely right about that, and then he didn't and acted just how he did here, that's no defense to interference with a police officer. You can't have your appeal as the police are right there.
So the first charge that was voluntarily dismissed by the Commonwealth after a motion to suppress
Right.
was granted
Right.
Was failing to surrender the firearms. And the Commonwealth made it an issue, even though it wasn't charged, made it an issue throughout the whole trial. If you
I know, but that's because it was relevant to the interference with a police
what
officer
did-
to sort of explain the story.
What did it interfere with? That's the question. Unless the
Well, but whether the police officer is technically correct or not, as long as they're not doing something against good faith, then we are, as citizens, required to follow police instructions, aren't we?
well,
And then take our remedy into the courts,
to the extent.
rather than resort to self-help, which is really what this was.
Well, Your Honor, respectfully, I disagree with that because there's case law that suggests that when it comes to constitutional rights, a citizen doesn't have to obey illegal police orders at all times. Now, I'm not saying that, an unlawful arrest is a defense to resisting arrest. That's different. But if the court is suggesting what I think the court's suggesting, then we would allow police officers to enter someone's home, someone's abode, without a warrant, without exigent circumstances.
We don't have to go that far, right? He is screaming at his wife, don't speak to them, don't cooperate, I'm not going to turn over anything, right? Before we separate even from going into the house, isn't he interfering with their ability to speak even to his wife? To I mean, they're able to do everything they can to issue this suspension short of going into the home, aren't they?
So they can issue the suspension, yes, but that's where their legal right ends. Anything after that, any police action after that,
They can't ask for consent to go into the house from the wife?
well, sure they can, but they didn't have a consent.
But he doesn't let them do that. He interferes with that, doesn't he?
He doesn't, no, he
Says,
said,
don't talk to them. I'm not communicating with them. I mean, he goes pretty far, doesn't he?
well, he's talking to his wife, Your Honor, and he's clearly upset. I mean, look.
I'm not disagreeing that he's upset, and I'm just trying to figure out whether he's interfering. I agree with you, once they go into the house, they need a warrant. But before they go into the house, he's uncooperative and belligerent, right?
Yes, he's very upset, but just simply asking or instructing his wife not to talk to the police, he's not, by that very action, he's not interfering with the police's ability to still talk to them. Words alone, they can't be interference, especially when talking to a wife or a spouse. If I may,
You have a question, please?
yes, Your Honor.
What was your client convicted of?
Interfering with a police officer.
Do you maintain that there is such a common law crime?
No, Your Honor, there is not. There is no common law crime in this Commonwealth of interfering with the police officer because it is not established by usage and tradition like other common law crimes have been, like affray and mayhem. As a matter of fact, the legislature has repeatedly refused to enact a law that would make interference with a police officer illegal. There have been 5 different attempts by House members to introduce legislation to that effect. I believe they're all attached to the amicus brief by CPCS, and the legislature has said no all 5 times. In the historical context, interfering with a police officer has only been an aggravating factor to an assault crime.
But
So
we
it's-
have other common law crimes. Just because it hasn't passed doesn't mean it's not a crime.
Right, Your Honor, but it hasn't been established by tradition and usage, that's how we have common law crimes come into effect when Mass Bay Colony.
What about Commonwealth versus Hastings in 1845, Commonwealth versus Kirby in 1849, Commonwealth versus Tobin in 1871? Those are, it's been enforced, hasn't it?
My understanding from reading the historical case law, Your Honor, is that it has been recognized as an aggravating factor in an assault crime. As a standalone crime alone, it has not been recognized. It was recognized as a defense in a civil lawsuit to a constable's actions where the constable was a defendant in a civil lawsuit and that was deemed to be a valid defense. But otherwise, it has not been recognized. If it were to be recognized, I would respectfully submit to this court that it is extremely vague. We don't know what the exact elements are. The majority of states that have statutes about interfering with the police officer, they require either specific intent or at least knowledge about what.
We recognize resisting arrest, obviously, right?
Yes.
So if you interfere willfully and intentionally with a police officer short of when they're arresting you, there's no recourse then? There's no crime?
Not in common law, Your Honor.
So- Okay, go ahead.
I apologize. There are other crimes that are statutes, disorderly conduct, affray, a number of them. But this specific crime is not a common law crime. To the extent that it is so vague. It is so vague that it is unconstitutional from that perspective.
All right, thank you.
Thank you, Your Honors.
Ms. Johnson.
Good morning, Your Honors. May it please the Court, my name is Melissa Johnson. I'm an Assistant District Attorney in Middlesex here on behalf of the Commonwealth. And I'd like to start off with the common law issue since we ended with that issue. It all starts with the Massachusetts Declaration of Rights. It all starts with in 1780 when the legislature basically proclaimed that all laws are to remain in full force until altered or repealed by the legislature or declared unconstitutional. So it really starts from there. So we have this common law crime which has remained throughout, has never been repealed. There's never been anything passed that's basically covered the whole of the subject. And in fact, what's interesting about it is that even today, it's charged almost 3 times a year. Almost 3 times a year. It's in our district court manual, recognized common law crime. The reason why that's so important and so critical for Your Honors is because clearly there is a need for it. And I point that out because police officers, very little of what they do is actually criminal investigation. Most of what they're doing is community caretaking. They're directing traffic. They're responding to scenes. They're responding to accidents and emergencies. They're keeping the peace at parades and demonstrations. That is the bulk of what they do. And without this common law crime, they have no way to do their duty, to do their job in those situations where someone starts messing around with them or preventing them to doing their duty.
What do you say are the elements of that crime?
The elements of the crime are, as the judge instructed, are intimidating, hindering, or interrupting a police officer in the lawful performance of their duty. Now, one thing I do agree with my brother is that this court should give some guidance as to some kind of mens rea element to that. It's not in there.
Well, and it wasn't part of the instructions. I
It
think the
wasn't.
judge just read basically from the statute. And isn't it clear that it has to be willful and there has to be a specific intent to impede, to hinder?
I believe I agree with you, there has to be some sort of mens rea. I agree with you. What I don't agree with my brother is that it had any difference here. There was no objection, substantial risk of a miscarriage of justice standard, and there's just no view of the evidence that this particular defendant's actions were not willful or intentional or knowing. Now,
Well, the actions were intentional, and certainly as far as the willfulness is concerned, I can see with no objection that there might not be a substantial risk of miscarriage of justice. But if you impose on those elements the requirement of there being a specific intent, not just to do the act, but intend to hinder, impede, then there might be a substantial risk of miscarriage of justice.
I respectfully, Your Honor, I disagree with that. Clearly, the police officers came to his house. They told him what they were there to do. They presented him with written notice. They asked that he surrender his guns as a result of the notice of suspension due to unsuitability. And he not only affirmatively refused to comply with them, he was trying to get his wife to not comply either. So we have some affirmative
But mostly he's
action.
trying to speak to his lawyer, though, right? I mean, there's lawful assistance, right? That's the key part of this common law crime. What is the police are sort of crossing from what they can do to what they can't do when they say they're going into his home, right? And he's saying, I want to speak to my lawyer. That's mostly what he's doing, isn't it?
And the reason why he's speaking to his lawyer, or he wants to speak to his lawyer, is not, and I think this kind of dovetails into the other issue that we were talking about. In this particular case, he's not doing that to somehow perfect an appeal. He actually just wants to talk to his lawyer because his guns are expensive or sentimental.
He doesn't know what his rights are, right? He's trying to figure out what his rights are. And
That's true.
and actually, he's got a point. The cops don't understand that they can't go into his house, can they? They think they can go into his house. Can they do that?
Ultimately, the district court judge decided that there was no exigency which allowed them to go into the house once he was arrested. But that's really an implicit finding that, in fact, before he was arrested.
But I just don't understand how the statute works. Because I get it that they can suspend his license and they can ask for the guns, but it doesn't look like they can do anything more than that unless they get a search warrant or they have classical exigent circumstances, right? So doesn't he have a right to go, I'm going to talk to my lawyer, I don't understand this.
But if we're looking at the relatively narrow issue of whether he was interfering with the duty of a police officer in the performance of their duties.
In the lawful performance.
In the lawful performance of their duties. If you look at the statute, what it requires these officers to do is, if you look at Chapter 140, 129D, 131 subsection F, and 131 subsection D, it all starts with that suitability finding. And
I get the police are behaving completely appropriately. They've got this order. They're going there to get the guns. They can drop this order off. Don't they have to leave at that point?
no, they don't, Your
What
Honor.
can they do?
At that point, Your Honor, given the exigency of the situation, and here the police completely followed the directives of 131
They have
subsection D.
exigent, I'm confused, that's where I get lost.
Yes.
Is there an exigency that's different from exigent circumstances, meaning that you don't need a search warrant? Or that allows them to do something more than just drop this off? And where is that in the statute?
In the statute, in 131 subsection D, basically what the licensing authority can do, they have discretion in this situation to find unsuitability, but it has to be based on reliable and credible information that the licensee has engaged in some sort of behavior that suggests he may create a risk of public safety. That is the exigency which allows them
So then, was the judge wrong then in saying they needed a warrant to go into the house?
I don't,
You dismissed the case, right? Once you don't appeal that, you dismiss the charge of the,
we dismissed the charge because at that point, we believe we had no way of proving that these particular items in the safe were firearms.
but you also don't appeal that issue, meaning you
That's right.
think the judge is right, right?
Well, Your Honor, I certainly think it's sound in her decision that there were no exigent circumstances that allowed them to enter into the house once he was arrested, because he didn't have.
That's where I was before, though. I don't understand what this exigency you're talking about allows them to do if it's not exigent circumstances that allows them into the house.
But it does allow them to demand that he surrender the guns, and that's where their duty is,
They
to
can-
demand that he surrender the guns under the statute.
Okay, so they can demand it and then he doesn't do it. What happens?
They can arrest him for refusing to surrender his firearms.
Okay, so that's the,
Can you address, you said they follow the directives of the statute, and what I get from opposing counsel is that there really are two tracks. One is, we're gonna give you notice, and there is this benefit of a safe harbor. The statute says unless an appeal is pending. But what counsel says is, well, if they really wanted these guns and they waited 3 weeks, there was another provision of the statute where they could have gone to a judge, gotten an order, and immediately gotten the guns. So basically, having not gone through that portion of the statute, they elected more for the administrative portion, and that's wrong. You're shaking it, right? Tell me why that's wrong.
Okay, first of all, the 3 weeks, I'm not sure where that number came from. If you look at the record at page 22, it appears that the police only caught wind of this 51A and this medical report from a doctor the day that this all was happening. So I'll put that out there.
I will put that aside. All right.
The statutes that my brother was referring to are the extreme risk protection statutes that just were passed this past August. The difference there is that those allow what the police already have the power to do. Those allow, the 131 RS&T allow a citizen off the street, a concerned neighbor, a family member, an employer, a coworker, to walk into court and say this person is posing a risk of bodily harm to himself or to others. And that enables a process to go through a hearing, whatnot, so that that person that person's license to carry is revoked. The police already have that power under Chapter 140, Section 131D and F. Okay, at that point, they have the discretion. The statute actually says they have the discretion
So
to
once the
determine not only if someone's unqualified because of mental health issues, which is the end of the story, but also unsuitability based on reliable and credible information. So there's that discretion. And this court in the chief of police of Worcester County, or Worcester versus Holden, said that that discretion's okay. It's constitutional for them, for the licensing authority, the chief of police, to do that, to make that determination, as long as the strictures of the statute are followed. So you have that finding, you have a written notice, you go and you present that to and it's up to the discretion of the chief or the licensing authority to either present it in person or to mail it in. Now there's
All of that was done.
What's that?
All of that was done here.
All of it was done, written notice.
But the question is, what happens when he refuses?
When he refuses at that point, the police are faced with a public safety issue.
Well, can't one of them stay and one of them go get a warrant?
That's one scenario, but he is in that point in violation of the law. He's not
Why
surrendering.
can't he consult his attorney?
As long as he's not near his guns. But I think that was the issue here, is that separating him from his guns. And he's not turning them over pursuit.
Why not hand him his cell phone if you don't want him to go in the house?
I think there was at some point that they were trying to arrange some kind of phone call when things got out of hand. And he was simply refusing.
To what effect do we make of the words unless an appeal is pending?
That is something that your honors would look at as to this particular case and every other case. It really depends on the constellation of facts. So in this case, the police in their discretion, because of the public safety issue, because of the unsuitability, went and presented themselves in person and presented that written notice in person.
An appeal in this case can't be pending because he doesn't know about it.
It doesn't, no, he doesn't know about it at that point, but the police have made a determination that we're going to start this ball rolling because of public safety.
But when
issues.
And we're not going to just give them
And that's
notice
okay.
and walk away. So
And
you're
that-
saying the police have the discretion to give notice and walk away, or give notice and seize?
Or mail the notice in. As you can see, that was done in Hightower. And actually, what's interesting about Hightower, yes, the notice was mailed in. It really depends.
That seems weird, though. So if they came and his wife were there, and they go, we're here to get his guns, and she goes, well, I can't do anything, I don't know what you're talking about, you gotta wait till he shows up. She calls him up on the phone, and then he calls his lawyer and files an appeal. Then you can't get the guns, right?
At that point,
But you could, because of the happenstance of him being there, you could then arrest him if he doesn't turn it over?
but the
'Cause that
happenstance are
seems
the.
really an
The
odd
happenstance
statute.
are the circumstances of this case. That's what happened. That was
We
before
really
the
want, do we really want
officers.
the law dependent on happenstance as opposed to some kind of sensible process?
But it is the discretion of the officers. Holden and the statutes
And let's
says
talk
that.
for a moment about the judgment call the officers have to make in that situation, in which they have a notice from the licensing agency that this is an unsuitable person
Yes.
to handle the guns because of a domestic violence incident.
Yes.
Now, when the police approach, what his behavior and the way he handles the situation, and the 13 firearms locked up, and his wife, who he won't let talk to the police, how does all that factor into the judgment call they have to make as to what to do with him?
It's a very difficult judgment call. Obviously, they have determined that this person poses a public safety risk. They want to make sure he is not near the guns or has access to the guns. The alternative is untenable. Are they just going to walk away and allow him to keep these guns after he's been found unsuitable for 90 days?
My understanding, as I read the record, is it's not just that he's been found unsuitable after 90 days, but that when they talk to him, his behavior indicates perhaps he really isn't suitable. Is that valid, a fair characterization?
I think it's a fair characterization of some of the things that an officer is going to take into consideration, but the narrow issue as far as interference with a police officer, they're just going by the statute. They're looking at 131 subsection D, unsuitability finding by the licensing authority, written notice, we go present it to him, there's no appeal pending at that point.
So as you know, unfettered police discretion makes us nervous, right?
I understand that.
Okay, so I guess the scenario I have for you is this whole language about unless an appeal is pending. And I can see a situation where there is a domestic violence non-suitability issue. Someone has even one firearm's enough, and an appeal is pending for 90 days. The police, under one view of it, are supposed to let this person walk around with a firearm with the threat of domestic violence for 90 days, versus the police get to decide if they're going to immediately do this, go into the person's house, or mail something.
Right.
And that's your position.
Our position is consistent with Hightower and Holden. And Hightower said as long, and it's not unfettered, Hightower makes the point that you have to comply with the statute. Yes, there is discretion under the statute and under Holden, but you still need to have that reliable and credible information that this person is is a public safety threat. That has to be in the written notice, and the written notice is presented. At that point.
But the implementation of that is unfettered, right?
The
They get to
impl-
decide how they're
It is
going to.
part of the discretion. It is part of the discretion because an officer has to take into consideration, just like in this situation, the exigency of it. Do we immediately present him with this notice? Or is it something like in Pasqualone or in Hightower, where there was just some kind of ministerial mistake or something left out of an application? That's different.
But Hightower is interpreting the United States Constitution. And what I'm interested in is, under the Declaration of Rights, when the police have this much discretion as to what to do, is there procedural due process a need for a pre-deprivation hearing?
I do not believe there is, because under Hightower, and I know Hightower is a federal case, but even under Holden, which examines these as well, you have in certain circumstances, yes, the state can enact some sort of post-deprivation hearing as long as there is some process at the beginning, at the front end here, and we have that with the licensing authority making that finding, providing written notice. That, in combination with the post-deprivation hearing, is adequate under both Holden and Hightower. That is adequate because you cannot ignore the public safety threat here, because really, what choice? The other choice is untenable, really. What choice did the officers have? They can't walk away
The
knowing.
choice Justice Link just suggested.
There are different options, but unfortunately, that one may not have been available given what quickly
What time of the
unfolded
day was it?
afterwards.
What time of the day was it?
It was 8 o'clock at night, Your Honor.
So there's probably a magistrate available.
There may have been, but how quickly things unfolded, Your Honor, that may have,
Well, they arrested him, right, outside?
they tried to. There was a little bit of an issue with the arrest.
Did arrest him ultimately.
They did.
Yeah, it was outside?
It was outside of his home, yes.
Yeah.
If I could turn, if I could, do I hear you saying that because we're dealing with the common law crime, one of whose elements you say is the lawful performance of his duties, that we therefore need to reach whether or not the officers were acting lawfully here?
Well, I think it's part of the element, lawful performance of their duty. It doesn't mean if later on this court may determine that appeal pending means perfecting an appeal or something like that. You really have to go with what is a reasonable police officer acting in good faith, following the statute as they did.
Well, but you're saying that this common law crime has as its element the lawful performance of his duties. Is that not then something which, if the officer turns out not to be acting lawfully, means that there's no common law crime?
Your Honor, that's an interesting question. I would just direct this court to look at the resisting arrest statute, which is a very similar one.
Okay,
where-
but does that speak of the lawful performance of his duties?
I don't have it right in front of me, but I believe that it does.
And that's sort of the problem with a common law crime, is that there's no statute to take a look at?
Well, I think Your Honors can do a couple of things. Number one, you can look from guidance from the 2 federal cases that have come down recently, and also the appeals court that came down, all within the last 5 years, which all of them address the issue of the mens rea that is required and other elements that are required. This court can look at the willful interference with a firefighter statute to determine whether, what the meaning of that is. But there are plenty, and this is where I disagree with my brother, there's plenty here for this court to look at in terms of trying to give guidance to what the elements are here.
And so one of the elements is to hinder. If a
Yes.
person chooses not to cooperate with the police, does that constitute not hindering the police?
It depends on what it is.
Well, isn't that a problem? I mean,
In
if
this
the
case,
officer
yes.
says, "I'd like to speak to you," and I say, "I'd prefer not to speak to you," is that hindering the police officer in the exercise of his duties?
It depends on what he's doing, but
So
probably
you're saying that my
not,
silence?
Probably not.
Probably not, but arguably yes?
It may not be. It depends on what he's doing.
Well, I mean,
there's
isn't that
obviously a
precisely the
Fifth
problem the
Amendment
amicus is
right.
raising, which is that you're arguably now asking us to invoke a common law crime which makes the constitutional exercise of a right to silence a common law crime.
There is no First Amendment issue here. I can understand.
But there is a First Amendment issue with regard to our recognition of this common law crime, is there not?
I'm sorry, could you
There
repeat?
is a First Amendment issue, as well as a Fourth Amendment issue and a Fifth Amendment issue with regard to our recognition of a common law crime that makes it a crime to hinder a police officer.
Well, first of all, those issues could be brought up when the case is litigated. I don't see any First Amendment issue in this particular case. I think you have to examine what the officer's duty was right at this point, and at this point, these officers were going to serve a notice of suspension and demand that he surrender his firearms. So there's no First Amendment
And what did
issue
he do?
here.
What did he do, which you said was to, he didn't intimidate, I assume. You're saying he hindered or interrupted? What did he do here? What did he do, which you say is the crime?
He did not surrender his firearms when the,
What if he was legally entitled not to?
then he could have raised that at another point.
So you're saying that if you invoke a right which you have, but the mere invocation of a right is sufficient to
If
constitute the common law crime?
If the statute is requiring him to turn over his guns,
Well, isn't that the issue? The issue is whether the statute does require him to,
well,
which
the
we're-
officers
the one we're
are just-
struggling with.
And the issue is also the officers following what they perceive their duty is. In good faith, when they look at the statutes, they're there to serve a notice of suspension. They know that 129D requires this person to surrender the firearms without delay. That's what the officers were here to do,
Unless an appeal is pending.
unless an appeal is pending.
So if he had been better behaved and said, I'm calling my lawyer to file an appeal, and the cop said, well, we want your guns, would he have been in violation, and could they arrest him for that?
Your Honor, I don't think that that is grounds for an appeal pending. I think we're going to go down a rabbit hole if we're trying to interpret what a person is meaning. When I want to call my attorney, I need to call a friend, I need to call, I think we're going to go.
But you still, then they could have arrested him, and he would have been interfering, even though he has a constitutional right to, I'm just, the thing makes me nervous, I'm not sure
No,
I understand where the
understand
line
it.
is.
I think that I would just always go back to the public safety issue here, the issue that there is a finding of unsuitability, and the fact that they're following the directives of the statute in terms of that finding, and the fact that there's an availability of a post-deprivation hearing. There is always that
I'm not-
availability.
Is that what you
Worried.
mean by appeal pending, post-deprivation hearing?
I'm
What
sorry.
do you mean by appeal pending? Are we just to cut off that portion of the statute and just to ignore it?
I don't think it needs to be necessarily cut off, but in this case, there was no
No,
appeal
we
pending.
have to construe the statute. We have to tell you what it means, don't we?
I understand that, but in this particular circumstance, there was no appeal pending because the officers, in their discretion, decided to, because of the public safety issue, because of the unsuitability finding, present him his written notice, which he's entitled to, in person. There may be situations where, and many situations, probably most situations, where that's not going to happen.
Because it'll be mailed to them and they'll have the 90 days to file an
Yes.
appeal? Is that what you mean?
Yes, I do.
Okay.
All right, thank you.
Thank you very much.